Hello everyone, my name is Adit Saharia and I welcome each one of you to Know the Law powered by Advotalks. Today we will be dealing with a very important topic which is known as medical negligence. Before we actually delve into understanding what exactly is medical negligence, let's first understand what exactly is negligence. So negligence in layman terms is nothing but doing something which a reasonable man would not have done, or omission to do something which a reasonable man in guided and considerable circumstances would have done. So now let's understand what exactly do we mean by medical negligence. Medical negligence is nothing but the failure of a healthcare professional to provide a standard of service of care that results in harm or injury to a patient. Now, how do we understand that if one is a case of medical negligence or not? The traditional test in law in case of medical negligence remains the Boehm's test, which states that a doctor is not negligent if what he has done would be endorsed by a responsible body of medical opinion in the relevant specialty at the material time. And even the apex court, that means the Supreme Court, has in various judgment mentioned a few guidelines as to when a medical professional is liable for negligence. First one, if he does not possess the skill that he professed to have possessed, or he does not use his skills with reasonable competence. Now let's talk about liabilities. There are two types of liabilities when it comes to medical negligence. One is the civil liability and one is the criminal liability. In the civil liability, a doctor can be held liable under the Consumer Protection Act, where one needs to file a complaint under the Act to claim compensation. So if the compensation amount is from 50 lakhs or less, it can be filed in District Commission. If the amount is from 50 lakhs to 2 crores, it can be filed in the State Commission. And if the amount is above 2 crores, it can be filed in the National Commission. Liability. Now when we talk about the criminal liability, section 304A of IPC talks about negligence causing death. Now under section 304A of IPC, a person can be punished with an imprisonment of 2 years, or with a fine, or with both fine and the imprisonment. Now what if medical negligence is caused to you or your family? So there are a few steps that one needs to follow. The first one, make the concerned hospital as well as all the doctors involved in the treatment as the party to the suit. Second, name the doctors involved in the treatment. Third, provide all the relevant documents like treatment bills, prescription files, discharge tickets, etc. Along with the bills paid, you can also claim for mental agony suffered and loss of future prospects and income. Before filing the case, you should always consult with a lawyer and a specialist doctor to establish that the negligence was shown by the concerned doctor in the treatment. If you have any questions regarding medical negligence, or if you want legal help, you can always connect with Advotalks. We will always be there to help you and support you. Now let's come to a very important case of Dr. Balram Prasad versus Dr. Kunal Saha. Dr. Saha and his wife were the residents of United States and used to regularly visit India. Mrs. Saha developed acute pain, fever and rashes. She was admitted to AMRI, and there were several lapses on the part of the doctors involved. Failure to prescribe intravenous fluids and nutritional support, failure to maintain acceptable standards of hygiene, inconsistency monitoring of her condition, and a lot more, which eventually caused to leading her death. And the Supreme Court, after hearing this matter, awarded a compensation of 6 crores.